Welcome again to Florida Appeals Journal. I'm Jennifer Carroll, and remember, each week we're addressing issues that are important to both trial and appellate practitioners. And we also try to hit significant cases. If there's an earth-shattering case, we'll raise that. But generally, we're going to hit the important issues and the key cases relating to those issues, and then end our time with what are some good courtroom tips with relation to those issues. So this week, we're going to talk about judicial notice. What the heck is it? How do you get it? And how do you make a very effective use of it in the courtroom? Now, judicial notice obviates, really renders unnecessary having to put something into evidence. If it's the type of thing that's without dispute, it doesn't really need to be proven. So what you're going to want to do is go to your evidence code and look at 90.201, 202, 203. And in your 01, it's going to tell you what the court has to take judicial notice of, and that's compulsory. And it's exactly what you would be thinking. Of course, opinions, rules of court of both the state and the federal. So, of course, you don't need to establish an evidentiary predicate or foundation for getting that into evidence. That's a no-brainer. But the interesting section is section 202, where you can have discretionary judicial notice, matters which may be judicially noticed. And if you look at that section of the Florida statutes, you're going to find several items that may be judicially noticed. And the one we're going to talk about today is a very popular one, but it's records of the same court or other courts. But regardless of which one we're talking about, you do have to follow a certain procedure with getting those in. And that is what you're going to want to remember when litigating the case. The matters, then again, that can be judicially noticed by the Florida courts, you're going to look at 201 and 90.202. And the procedure is laid out in 90.203. That's the most common one. And basically, under that, you're really going to, and I'll quote that statute to you. A court, 90.203 is entitled compulsory judicial notice upon request. So you have 201 tells you when a court has to, just on those three things that I'd mentioned previously. 202 is the one that talks about the 13 items that a court may take judicial notice of. But if you really have to get that into your case, you're going to want to look at 90.203, compulsory judicial notice upon request. And that states that a court shall take judicial notice of any matter in section 90.202 when a party requests it, and one, you have to give each adverse party timely written notice of the request, proof of which is filed with the court to enable the adverse party to prepare to meet their request so that they can respond or they can object. And then two, you have to furnish the court with sufficient information to enable the court to take judicial notice of the matter that you're seeking to have compulsory judicial notice taken. So those are the main provisions. And as long as you comply with those procedures in 9203, the court is required to take judicial notice of those matters you're trying to get in under the 202. Okay. And that's going to be mandatory, just like under 201. Those three basic items are also compulsory. And one thing to remember, and this is, I'm going to cite a couple of cases here, because I think these are some good cases to use in your arsenal when you're addressing this issue. You have to remember, basically under the provision we're talking about today, subsection 6, the court can take judicial notice of records within its own court, could be another division, or of other courts, okay, outside the jurisdiction. If you are able to get judicial notice taken, say, of a file, you want a whole court file from another case, or a document from another case, remember, it doesn't mean you automatically get everything in that file in evidence. you're still subject to the rules of evidence. And 403, the balancing of relevance and prejudice. But really remember the hearsay rule, because just because it comes in under judicial notice, you can have hearsay, then within hearsay. So you still got to be on top of all of that. So I'm going to give you a case. And let's see if I can see this right. Do for DUFOU v. State, and that's 69 7th 3rd 235 and 253, and that's a Florida Supreme Court case. And the Florida Supreme Court stated, while the court may take judicial notice of documents in a court file that were properly placed there, this notice would not make the contents of the documents admissible if they were subject to challenge, such as when a document is protected by privilege or constituted hearsay. In addition, judicial notice of an entire prior proceeding may be expeditious for the current proceedings, but it does not allow the substance of the underlying materials to be entered into evidence without compliance with the rules of evidence. So you want to remember that case. There's a good fourth DCA case, Holt v. CALCHAS LLC. That's 155 Southern 3rd 499 at page 507, and Florida 4th DCA 2015. Although the trial court could take judicial notice of the court file, the rules of evidence, including hearsay rules, still apply to the information contained within that court file. So I think that's critical to remember that, because you will need that. So it's not wholesale admission, and there are a lot of cases on that point. Another interesting issue to keep in mind with this doctrine, with the judicial notice, is normally it used to be litigants would try to get the trial court to issue a separate order adopting the record. You really don't need to do that. Again, just follow the procedure set forth in 03 and 04. And when you look at the secondary sources on this area, there's a consensus that with these provisions, 03, 04, you don't really need to use a certified copy anymore of something from an outside record. And that's interesting, because some of the case law out there, it used to be you really had to do that. So, I think that's actually a gray area, and I would be careful with that. But I know the secondary sources seem to have a consensus that no, it's not really needed in view of those statutes. And I wanted to also mention one more case, and that's the Falls v. National Environmental Products. That's a 4th DCA 1995, 665 Southern 2nd 320, 321. The appellate court said it's proper for the trial court and the appellate court to take judicial notice of the pleadings and briefs of other actions filed which bear a relationship to the case at hand. So, of course, I think relevance is extremely important, obviously. So those are some of the key cases to keep in mind with respect to judicial notice, and that in a very small nutshell gives you some idea of what to do with the judicial notice situation when you're setting up your evidence also. So the tip of the week relating to judicial notice is definitely you want to give notice ahead of time, well in advance of trial, so that the other side cannot argue that they were surprised and didn't have an opportunity to object. And you have to have that notice in order to invoke the compulsory requirement and benefit of Section 203. And then you want to know your evidence rules also. Don't assume because you're putting in, even if it's one document you're getting in, there could still be hearsay within that. So you're going to have to get past all your traditional evidentiary hurdles. So that's it for this week. Quick and easy. And as usual, if you have any thoughts, any issues you want addressed on our journal, please email us and let us know. Thank you again. Hi, I'm Jennifer Carroll, and I want to thank you for watching our video. You can see more of our videos right here. Or better yet, subscribe to our YouTube channel below so you won't miss a single one.